Hi everyone, my name is Haley Frith and my topic is on the competency to exercise the right to remain silent. As I read about my topic, I kept thinking about the West Memphis 3 case. This case was devastating to everyone involved. It took place in West Memphis, Arkansas in 1993, where 3 8-year-old boys were found murdered. Jesse Miskelly Jr., Damian Eccles, and Jason Baldwin had all been convicted without any actual physical evidence, but instead based on Miss Kelly's confession that the 3 teens had murdered them. But as we'll learn, many unethical tactics occurred during this interrogation, including it being an almost 12-hour interrogation without any counsel or parent present, since he was under the age of 18, especially looking back and learning about Miss Kelly's intellectual disabilities. I attached the transcripts and audio of the interrogation to the presentation, but I'll also link just the transcript and a summary of the case. I will say that listening to the audio illustrates Miss Kelly's disability much more than actually reading it. And also, please pay attention to how much the detectives use questions to lead Miss Kelly to their desired answer. I would say listen or read just up until about the 9-minute mark. To determine an individual's competency to remain silent, let's first look at the laws of confessions. To ensure that an individual is competent enough to waive their right to remain silent, they must do so in a state of mind that is knowingly, intelligently, and voluntarily. This means that they must understand their rights, be intellectually capable of waiving them, and voluntarily waive their rights to remain silent, which could potentially lead to self-incrimination. Although it's important to note that there are instances where individuals can self-incriminate themselves before a Miranda warning is given. For example, according to Melton et al., 2017, if the suspect has information that would protect against immediate danger to the public during booking and when the prosecution uses it to impeach a testifying defendant. As long as these examples are done in a manner where the individual has voluntarily confessed, this means that there was no coercion, and the interrogation or questioning must cease once a person states that they don't want to talk or invokes his right to counsel, which can occur at any time. Another point is that Miranda warnings are not given to individuals who are not suspects and are not in custody. This competency issue is brought up before the trial begins and usually occurs at a suppression hearing. The defendant's counsel might argue that their client, quote, was incompetent to waive their rights under the 5th or 6th Amendment or the Due Process Clause, unquote, according to Melton et al., 2017. Once the question of the defendant's competency has been raised, a mental health professional will evaluate and assist the court by providing their findings and understandings to help the court make a decision. There have been 2 precedential legal cases that have imposed constitutional limits on interrogations, as well as self-incriminations. Brown v. Mississippi in 1936 was the first case imposing constitutional limits on police interrogations, according to Melton. Also, according to Melton, 3 African Americans were coerced by extreme physical torture into writing a written statement incriminating themselves. It was argued that the defendant's 14th Amendment was violated. Then 30 years later, Miranda v. Arizona in 1966 occurred, raising the issue of self-incrimination and whether confession would be inadmissible. This case implemented the per se rule, where anything before the suspect is given their Miranda warnings or when they invoke their 5th Amendment right could be deemed inadmissible. Another important thing to note is that although there have been laws instated that protect an individual's rights when it comes to confessions and interrogations, there are still questionable tactics that the police use to interrogate that are considered to be admissible. As stated by Melton et al., 2017, the court justified its holding on the ground that although the police action may have been fraudulent, it did not result in the compulsion banned by the 5th Amendment or the coercion prohibited by the Due Process Clause. Some of these practices include confessing a crime to an inmate who was actually an undercover agent, those who believed that only written statements were admissible, so they voluntarily gave an oral statement, Another one was if a suspect believes they are being questioned about one crime but instead were questioned about another. Another, who were not told that their attorneys were trying to reach them during the interrogation. In one case, police use the tactic that if the suspect doesn't tell them where the murder weapon is, then children might find it. Police say that they have physical evidence they do not actually possess, or that a confession will make the suspect look better at trial. In the case of Colorado vs. Connolly in 1986, Connolly flew across the country to confess to a murder that he had committed months before. The police didn't suspect mental impairment, gave him his Miranda rights, and even reminded him multiple times that he didn't have to talk. Regardless of those reminders, he still insisted on confessing. Afterward, a mental health professional evaluated him and noticed that he had been admitted to multiple mental hospitals and that he had been off his medication for many months. Connolly told the psychiatrist that he felt compelled by God to confess. Despite his mental health, the Supreme Court ruled that he had knowingly and voluntarily admitted guilt. The court's reason for this ruling was that the police did not suspect mental impairment at the time of the confession, and the court had no proof of coercion. There are many ways that mental health professionals help the court on determining admissibility. According to Melton and co-writers in 2017, 4 forensic assessment tools are used to determine whether the defendant knowingly and intelligently confessed. Assessing whether an individual voluntarily confessed is difficult, since the term refers to something that occurred retrospectively. The mental health professional will also inquire whether the defendant is suggestible, how they respond to authority figures, and whether they may have been under the influence at the time of confession. As I mentioned in the last slide, there are issues with evaluating competency regarding an individual's right to remain silent. The first requirement of competency is that an individual must have knowingly confessed. The problem with this is that according to Melton and colleagues in 2017, many competent adults have misunderstandings about the Miranda warning. Some of these misconceptions include believing their silence may be used against them, meaning they feel like they must cooperate and talk to the police so they don't appear guilty. Another misunderstanding an individual may have is that only written statements, not oral ones, are admissible, according to Melton and colleagues. The other issue in evaluating a person's competency is assessing their intellect. Studies have stated that individuals need at least a middle school reading capability to understand the Miranda warnings, according to Melton and colleagues in 2017. Although there are 4 different assessment tools to evaluate one's intellectual capacity, none of them are perfect. And as a recap, assessing the individual's voluntariness of confessing is much more challenging because it is done retrospectively. What are your thoughts on how the court relies on individuals voluntarily confessing to crimes when we know from the last slide how difficult it is to assess something retrospectively? Do you think that courts should put as much weight into a confession from someone who may or may not be competent, or do you think that one of the other requirements should be more important? Here are my references, and thank you so much for listening.